Thank you. Please be seated. We are here today, this afternoon, for the submission of 4 separate cases. The first case is Fortune versus State of Iowa. Second case is Sand versus John Doe. Third case is Betcher versus the State of Iowa. And the final case for the afternoon is in the interest of AB and IB. We'll start off the first case of Fortune versus State by doing a sound check. We'll start with Mr. Lundquist. If you would please give a sound check, and I'll have each Justice McDermott and Apple respond.
Good afternoon, Chief Justice.
Very good. I can hear. Thank you.
Thank you. I can hear you also.
Thank you. You may be seated. And Mr. Mears, if you'd like to do a sound check, and when we're sure everything's okay, then you can begin.
So this, I guess, is my sound check.
And it's working just well. Thank you.
Works here too. Thank you.
You may proceed. Thank you, sir.
Good afternoon on this cold day in my first time in a courtroom since last March. Actually, the first time to appear in person in a courtroom since last March. In 2009, the Iowa legislature substantially rewrote Chapter 692A of the Iowa Code, which is the sex offender registry statute. At the same time that they were starting to require yearly or monthly or quarterly personal appearances by registrants and a substantial increase in the amount of information that had to be given to the sheriff, they included Section 692A 128, a provision that allowed for the modification of the conditions of the sex offender registry. That in 2014, this court essentially breathed an element of life into the statute. I think in the first 5 years before the Story County case, there had maybe been 10 modification cases because of a restrictive interpretation of the statute. With the Story County case in 2014, individuals who were no longer on supervision, who had been convicted in adult court, were able to bring modification actions. Now, this didn't exactly create a floodgate. The Department of Public Safety statistics indicate that as of about the first of this year, there'd been a total of about 300 successful modifications in those 10 years. Mr. Fortune's case is perhaps the first opportunity, however, for this court to address what the statute really means that a district court is supposed to do beyond looking at sort of the particulars of the assessment by the judicial districts. When I try to think I can be organized in a presentation like this, I wrote down that there were 3 things I wanted to talk about. I wanted to talk about the statute in general, how it should operate, and our suggestion for how it should be interpreted. Secondly, a few specifics with regard to Mr. Fortune's case. And third, specifics with regard to the exercise of discretion in this case by Judge Stobie. Let me talk about the statute. What is clear is that the statute sets out that there are either 3 or 4, and for lack of a better term, I'm going to say factors that you say factors, it could be preconditioned, it could be prerequisites. Those are different alternative ways of saying the same thing. The statute says in order to be modified, you have to have been on the registry for a minimum period of time, either 2 years or 5 years. Second, you have to have completed sex offender treatment as required. I actually have a complicated case at the moment where the person's offense was so minor that they didn't require treatment at all. and the question of whether that, but that's not here. The last requirement, and perhaps the most potentially complicated, is whether or not the person is low risk to reoffend as measured by validated sex offender tools developed by the Department of Corrections. I might add, and not for this case, there's a fourth requirement that if you actually are on supervision at the time, the district director of your judicial district has to stipulate to the modification request, whatever stipulate means.
Mr. Mears, would I be correct in my statement that it's undisputed that your client qualified to ask for this? There's some people that might try to qualify and don't even hit the initial requirements. But in this case, it's undisputed your client qualifies to at least ask. He meets that criteria?
I think so. That the judge, one of the tests that was used, the static 99 test, which is perhaps the most well-known test, known nationally at least, internationally, that he scored average, but that when that was combined with all of the other tests, the score was overall low. Even Judge Stobie sort of somewhat begrudgingly acknowledged that he seemed to be low risk.
I guess let me jump to the chase here. Let's just assume, for argument's sake, that your client has satisfied all of those qualifications to even ask for it. Is the rub of your case that the court cannot consider other factors? Or because you've talked about the risk of reoffending. To me, how I'm trying to grapple this is, it seems to me, especially for an abuse of discretion, we can't say that this court did not look at the risk of reoffending. You're just not liking the weight that he attributed. Is that correct?
Well, the question really comes, I mean, the statute says that if you meet those prerequisites, the district court may modify, uses the term may, which generally connotes discretion. And the question is, so what? That what if you have a judge who says, I've looked at the risk assessments, but that for your particular kind of offense, I don't think anybody should ever be modified. That when I look, so that
Mr. Mears, how would you articulate the standard that should be used to guide the district court's exercise of discretion?
Well, I think about the AJM case, and that I mentioned that considerably in my brief, which is where this court wrestled with sort of another case where there was discretion to put or take off a juvenile on the registry. And that I believe the AJM case said that in considering whether to, or when you are exercising discretion, risk for reoffending is the central thing that you ought to be looking at. And so as to other factors, I think, for example, that if you had an exercise of discretion that said, I'm never going to do it in a sex third case involving a family member, for example, that I think that's an abuse of discretion, because elevating a factor that doesn't really relate to risk would be an abuse of discretion.
So what kind of factors would relate, given that one of the prerequisites is a risk assessment that assesses this particular offender as low risk to reoffend? I mean, that's a given going into these petitions
Well,
to modify, right?
and
So there
that's-
has to be something else that we can look at.
Well, first of all, at least with this waiver or modification statute, you've got some criteria set out in the statute that was different than what appeared in the juvenile waiver statute. That I would favor an interpretation of the statute that would essentially establish almost a presumption of modification in the event that the person shows that they are low risk to reoffend, keeping in mind that the purpose of the entire registration statute is protection of the public as opposed to punishment for the individual.
Counsel, go ahead, Justice Mansfield.
No, go ahead.
I was just going to ask, what do you make of the state's argument that you're then trying to rewrite this statute and cutting the word may and putting in the word shall, if that's how we were to interpret it?
Well, the fact that you have a gloss of, that you're primarily looking at I'm sorry, I sometimes not quite sure where I should look in addressing someone who's remote.
You can't go wrong. Don't worry about it. Other than if you maybe look to the door.
I don't think that, I mean, the question is, what did the legislature intend? Because that ultimately is to some extent what you have to consider. And that I think the legislature intended that people who were in fact low risk, which is in fact a very low risk, should be able to come off the registry after a certain period of time. And that to create, that if a judge wants to elevate a factor above that, you have to have something at least, that the judge would have to articulate that factor in terms of risk. That in this particular case, for example, Judge Stobie said that my client's interest in being a first responder was an effort to be able to get contact with more children. Well, I mean, there's nothing in the record to support that kind of a conclusion, and I suggest that that particular example of an exercise of discretion is not related to risk.
Well, in a sense, Mr. Mears, wouldn't you agree? I mean, you say in your briefs that it's kind of like reviewing a sentencing decision.
That's right.
And what we typically do there is we end up remanding if there's a problem, because the problem is usually consideration of an improper factor or an improper consideration. But it's very hard to affirmatively tell judges how to sentence, because that's ultimately a discretionary call. So, you know, in this case, if we were to conclude that Judge Stobie relied on some factors that were improper, and I agree with you that maybe the consideration that he doesn't really need the modification. I would argue that these are pretty burdensome registration requirements, and anybody would like to be free from them if at all possible. You know, if we say that's an improper factor, or maybe we say there's other improper factors, and then remand for a new hearing, is that something that we could do? Would that be a viable solution?
I think so. I mean, but thinking about the sentencing analogy, however, sentences, if I am not incorrect, can be punitive. If anything, the reasons that you exercise discretion in this kind of a case are probably more narrow than the things that you could do as part of sentencing. That is, that being aghast, or whatever the term the judge used in this case to describe the offense of Mr. Fortune, begins to sound as if it's punitive, and that could be done in a sentencing proceeding, but I suggest that can't be done here. I think there has to be a gloss, but in answer to your question, I don't think I'm asking this court to grant Mr. Fortune's request on appeal. I think the appropriate thing would be to direct the discretion better and send it back for reconsideration. Among other things, by that point, you know, a year and a half will have gone by, and Mr. Fortune's risk will, I mean, I hope you picked up on the part of the brief where I talked about risk declining over time. That is, that the statisticians, and my goodness, reoffending for sex offenses has been more studied than reoffending probably for anything.
Well, let me ask you, you said you wanted to talk a little bit about your client, so let me ask you a little bit about your client. Sure. Isn't it fair for Judge Stobie to have considered the fact that your client did pick up that conviction for not complying with the terms of the registration statute when he was using an alter ego on Facebook. Isn't that something that's fair for the court to consider?
Well, you still have to make it related to risk, it seems to me. And that if you look at the statistical measures of risk, that a subsequent sex offender registry violation that's unrelated to a sexual move is not related to risk. The other thing about, I mean, I suppose you could have a sex offender registration violation that could be more technical. I mean, that Fortune got the minimum sentence that was available for registration violation. You can't get it deferred by statute. That he got a fine, no jail, and that was it. That this was, I suggest, a determination by the prosecutor that this was a fairly minor violation and that it was unrelated to risk. That I think, what it does suggest, however, is that, as the United States Supreme Court said in the Packingham case, social media, the restriction on social media, that social media is an important thing for people in today. Mr. Fortune wanted to get access to Facebook to be able to sort of find out about what his friends and family were doing. And that when somebody snitched him off to Facebook and he was thrown off in his own name, he got another name. That was a technical violation.
That sounds good, but isn't it also pretty common and popular for Facebook to be used to prowl?
Sure, but there was no evidence of that in this case.
Okay, if you'd like to wrap up your first half, your first argument, then we'll move on.
I'm sorry.
Time is up if you'd like to wrap up.
Okay. Again, what I would say in conclusion is that clearly the legislature gave courts discretion, but discretion is not a toothless sort of review. And among other things, what this court needs to, there hasn't been an opportunity for this court to say to district courts how that review should be governed. I submit that looking at the AJM case, that the standard should be whether or not risk is affected.
Thank you. Mr. Lundquist, when you're ready.
May it please the court, Chief Justice Christensen, fellow justice.
Counsel, you need to turn your mic on, I think.
That was a
Thank
sound
you,
check.
Justice
There you go.
May it please the court again. Chief Justice Christensen, fellow justices, Mr. Mears. My name's John Lundquist. I'm from the Iowa Department of Justice, and I'm here to represent the state of Iowa in this matter this afternoon. This court has repeatedly held that the paramount purpose of the sex offender registry requirement is to protect society from sex offenders after they've been released back into society. The legislature's chosen means to accomplish this public safety goal is to require that all qualifying sex offenders register with the Department of Public Safety and that the public have access to that registrant's relevant information through their webpage. Iowa law therefore creates a presumption that all sex offenders shall register, and exceptions to this norm should be strictly construed so as to not undermine the statute's public safety goals. Now, as Mr. Mears indicated, Section 692A 128 does create one avenue for modification of these registration duties. This is only available after the specified preconditions are met. And in answer to the Chief Justice's question earlier, the state would concede that all of those prerequisites were at least minimally met in this case, and so that Mr. Fortune was eligible to seek the modification that he applied for in this instance.
This is a just abusive discretion case, and of course, I think that was conceded by both parties as well, of course. But would you agree with me that for someone to qualify, that's not probably the norm? Those are some pretty strict criteria just to get your foot in the door for you to have the ability to challenge or to ask for this modification?
Clearly, the legislature felt that only a select subset of people should be eligible to be considered for this. And chief among those probably are the fact that they have completed any requisite required sex offender treatment. And that based upon their scoring on a validated risk assessment tool, that they be at low risk. But as you indicated, this is an abuse of discretion case. The statute's very clear that the court may grant that modification. It in no way compels the court to act in any particular way. Simply meeting the prerequisites opens the door. It doesn't guarantee that a modification is actually available to any particular offender. Now, unfortunately, we're here today because the statute doesn't provide, I would say any guidance, at least minimal guidance, as to how that discretion should be exercised. But I would say that if you look at the plain language of the code, the mere fact that someone has met those preconditions does not create a presumption that modification should occur. Now, the code does offer some clues as to the scope of information that the district court is eligible to look at. It states in subsection 5 that the court may, but is not required to conduct a hearing on the application to hear any evidence deemed appropriate by the court. So clearly the legislature felt that that district court judge can make a determination as to what information, in addition to those prerequisites, it deems appropriate and relevant to the inquiry. And
With me that it really isn't relevant. I mean, the district court here, as one of its reasons for denying the modification, said, well, Mr. Fortune is able to hold down a job even with these registration requirements in place, and so he doesn't really need the modification. That's not really an appropriate consideration, is it?
well, I think if you even look at this case's ruling in AJM that was referenced earlier, that modification exists for multiple reasons. Among them is to alleviate the difficulties that someone may face as a consequence of registration. And so, for instance, if someone were having difficulty getting into a care center because of the 2,000-foot restriction, modification would be relevant in that instance. So I think,
Do we want to punish success if somebody's able to land and keep a job despite being on a sex offender registry? Should that count against him in getting a modification?
I think it's a factor to take into account. Clearly registration is onerous. I'm not going to sit here and try and tell anyone that registration is not onerous. However, the legislature made the call that if you commit certain offenses, you need to register for a certain amount of time, and that's their preferred means of maintaining the public safety. Now, this
So
court...
let's assume you had a case where there was a very, very low risk of reoffending. That's the record we have. Is it your position then it would be sufficient to deny the request for modification for the sole reason that the applicant didn't need it?
I don't think I would take that position, no. I think the court needs to be able to articulate as to why it felt in that circumstance. As this court stated in AJM, the court's delegated discretion may not be exercised in a way that would undermine the public protection provided by the statutory scheme for registration. So I think in the back of everyone's mind needs to be that public protection element. And
that was, I guess, going to be my follow-up. I mean, don't you think whatever specific facts the district court looks at, they have to be looked at from a view of public protection and safety. And if they're considered for some other reason, whether it's punitive or necessity, whatever, then wouldn't that be an improper consideration?
You know, I think at the end of the day, the reviewing court does need to take into account that public safety goal and be able to articulate why whatever factor they're considering relates back to that public safety goal.
Is it reversible error for the court to consider this so-called quickie marriage where 2 weeks, after dating someone for 2 weeks, then a DHS investigation of he's around her children, and then he marries her, thereby ending the DHS investigation? Is that fair game?
I think that has relevance in the overall scheme here. Couple that with his activities in what resulted in his failure to comply charge is a affirmative act on his part to try and either evade or avoid people knowing what he's doing or taking into account his actions in the community contrary to the purposes of the statute. So,
Well, is there any evidence in the record other than that he complied with law on this, around this marriage business? I mean, is there any evidence to suggest that he was in non-compliance and that the marriage was a sham or anything like that?
Justice Apple, I'm not aware of anything in the record specifically. Clearly, he admitted as part of his testimony at the modification hearing that the desire to avoid DHS conducting the investigation was weighed heavily in his decision to get married.
But counsel, isn't it also true that happened, that the marriage was like 6 years before the hearing, and by the time of the hearing, the kids are now 15 and 25 years old? Does that play into the factor at all?
You know, clearly the district court felt that it was relevant to exhibiting risk factors that he engaged in certain behaviors, and I wish Mr. Fortune success, that he does appear to have had a successful marriage and that the children have become older.
Counsel, what about the district court's citation to the underlying nature of this crime? The court cited to the fact that, you know, the crime that he was convicted of in 2003 was particularly bothersome. Is that something that the court should be looking at in analyzing what it has discretion to analyze in a case like this?
Justice McDermott, I do believe, yes, that the underlying facts and circumstances of the crime are relevant to determining as to the degree of public safety that may be necessary.
Here's the question I want to raise, and I may ask Mr. Mears the same thing. We think about risk to reoffend. That's sort of, as judges, we think of that. But I think to the public, if you ask them what role this registration law serves, it provides information. And they want to have information about people who committed serious sex crimes, really, I think, regardless of how long ago or regardless of risk to reoffend. And are we entitled to view that as part of the purpose that the legislature was intending to serve with the statute?
You know, the statute is guided by public safety, and the way in which you achieve that is through the very dissemination of information that you discussed, that people can make decisions as to who they want their families socializing with, where they want them to be going, or who they may encounter at other events. So I think that
people may be irrational. They may feel it may be a situation that this person, those events are far in the past, many years have passed, the person has been successfully treated, but the public may still feel we want to have the information. Is that something we're entitled to take into account?
You know, I believe that plays and that is relevant to the ultimate public safety goal. Just because something happened a long time ago in the past doesn't mean that, you know, as I indicated in my brief, someone who's engaged in a single act of indecent exposure probably doesn't warrant the same degree of scrutiny as someone who engaged in years-long misconduct against people who weren't able to defend themselves.
And you can correct me if I'm wrong, but in this case, I don't believe that subsection 4, 692A.128.4 occurred where the county attorney Either they notified the victim or the victim did not participate in this hearing, is that correct?
I believe that they weren't able to locate the victim.
They were unable, so it's not that the victim had no problem with it. The statute says if the victim's address is known.
Yeah, and Mr. Mears can probably correct me on that, but it's my understanding, as I recall reading the record, that they were unable to identify an address for the victim in this case. So, and I believe that the victim's views, are relevant as well, because, the statute obviously requires that notification go out so that the district court can hear those viewpoints and make an informed decision as to whether or not, what effect did this person have in their life, and is this someone that deserves the scrutiny of being on this list in a manner that the public knows who they're interacting with.
Counsel, what is your response to the district court's reliance on the fact that Mr. Fortune wanted to be a volunteer firefighter?
Part of the nature of the crime in this particular offense, it was a young person, and having opportunity to groom additional victims would seem to have some relevance. I'm not sure how much. Clearly, factors have more bearing than others. I think the most important factor in this case dealt with the fact that he had been convicted of failing to comply with registry requirements, and that his failure in that case did involve his desire to avoid detection on the social networks of Facebook.
Wasn't that really the only ground that the state argued for not modifying the registration below, and then the district court added these other grounds in its ruling?
That's entirely possible. As I recall the transcript in this matter, that the state primarily was concerned about the prior criminal history of this gentleman relating to both his registration and then to a lesser extent that disturbance that arose out of a domestic situation. However, as the statute says, the court can hear any additional evidence it deems appropriate. Lastly, just want to touch on the AJM case and how that dealt with this notion of juvenile waivers. And AJM itself makes clear that there is no companion waiver provision for adult offenders, although modification does exist. There is a comparable modification provision for adult offenders. And so this notion that AJM stands for, that in making a modification, all you should look at, or the most important thing you should look at, is risk, I don't think is the case in this instance, because we aren't talking about waiver in the context of juveniles, where the juvenile court has the authority to take someone off the registry up front, but only if it makes that determination that there is not an undue risk to reoffend. Whereas modification, you can deal with additional factors in addition to risk, as long as at the end of the day, the court circles back and is able to identify how those factors are relevant to promoting the legislature's public safety goals. So I would ask that you please affirm the district court. Should you feel that an abuse of discretion has occurred here, please remand with instructions as to the appropriate standard to apply. And I want to thank you for your time this afternoon.
Mr. Mears.
Justice Mansfield, may I turn my microphone on? Let me address what you said you were going to ask me about. Doesn't the public perhaps sort of want to know stuff and that's one of the reasons for the statute? Well, quite frankly, I think the public would probably want punishment. And that to the extent that the public has an interest beyond actual safety, that interest is in punishment. And quite frankly, that's a role for the courts to make clear, particularly when you've said for 25 years, this statute is not punishment. This statute.
a pretty strong statement to say that that's what people would want. Wouldn't a homeowner want to know, just, I'm not going to buy that house if I know so-and-so is next door, or I've got kids in the neighborhood, or I don't want that person, I was going to have his wife babysit for me, but now I know about her husband, or whatever it may be. But aren't there some less drastic reasons that the public would like to know this, or maybe needs to know this?
Perhaps, but I guess I've done about 100 of these cases, and that maybe sort of a half to two-thirds of them were contested, and of those cases, maybe about half had victims appear and say something. And I can tell you that based on that unscientific sampling, victims certainly want punishment.
I have the anecdotal cases for you too, but I also think that the opposite is true, of course. But you're right, as far as the victims, more punishment probably is what they want. But I'm talking about the general public when they look it up and they see someone's on the registry, and they may not even know who the victim is. But that was just my concern was that you're making it a pretty broad statement. I think there are more reasons for the public to want to or need to know.
But I do think that the public could also have an interest in punishment, and that when this court sets the standards for the exercise of discretion, one thing the court can emphasize is that whatever the factors are you want to reject someone who gets in the door, that those should be related to risk.
So then I think we're boiling down to where I wanted to get with you. So you agree that the judge has discretion, and of course the risk to reoffend is a biggie. That's a big part of the analysis. It has to be. It's part of the statute. It just plain has to be. Do you also agree that the court may consider in its discretion other factors, just like that statute that was referred to by the state where other evidence can be taken? So do you agree there's other factors besides the risk to reoffend?
Well, a sentencing court can consider other factors, but there are discretionary limits on what the sentencing court can consider. That non-charged, non-admitted bad acts, for example, of the defendant. That it seems to me that when a court looks at other factors, other criminal acts, for example, that in order to override getting in the door with a low-risk sort of moniker, that the court has to be able to connect it up in the end to risk and public safety.
I was actually, I thought that your argument in your brief was well done when you're talking about the 5 different tests, and 2 of them are kind of consolidated with others, and they kind of use different tags, and that can result in a problem when you're trying to say very low risk. Well, another one might say moderate risk, whatever, that the words get in the way. But in this case, if I would give it to you that he was low risk, the lowest risk you can be to reoffend, I'm real concerned about all the other factors. In this case, if we peel back some of them that may have gone a bit too far, weren't some of those, some of them that were alleged pretty concerning, such as 2 violations, one of them involving sex offender registry, and perhaps the marriage if his own testimony was to dodge the DHS?
Well, you know, I was around, because I've been around for a lot of stuff, but I was around when the legislature enacted that child endangerment amendment, and that I don't think that the legislature understood that what that was going to do was get a lot of people married, and that these people consulted, Mr. Fortune and his now wife consulted with a lawyer who explained how the statute worked, and they got married. That they complied, they did what the legislature had said they would be able to do, which is to get married, which prevented the child abuse, the child endangerment from taking place. I don't think that of all the different factors that the judge considered, that I don't think any of them can be related to or certainly override the fact that he's not only low. I mean, one of the things to understand about low risk is really small. I mean, we're not talking about less than half. We're not talking about even 10%. We're not even talking about 5%. We're talking about small numbers, that 1 out of 50 people, perhaps.
You may wrap up, Mr. Mears.
The legislature in 2009 added the modification statute. All of a sudden, registration lengths that were 10 years or lifetime sort of had an out. You got a parole. While you previously might have had a life sentence, now you could get parole consideration. Think about it with kids in prison. That the statute does in fact give a district court discretion, but the district courts need to know how to exercise that discretion. This case provides this court with a good opportunity to be able to address what kinds of factors can and cannot be considered in exercising that discretion. And again, in exercising discretion, you are to give due weight to the important factors. And here, I don't think Judge Stobie gave appropriate weight to the factor of that he was such a very low risk in any criminal offense. The sexual offending was a minimal offense, as evidenced by the sentence he got.
Thank you, Mr. Mears.
Thank you so much for your time. It's kind of nice being back.
Things look a little different, but it is good to be back. Thank you. The case of Fortune versus State is hereby submitted. While the attorneys from that case are gathering their stuff, we will take a brief break for the sterilizing. And then when they're done with that, the second case of Sand versus Doe can take their places.